there's been this response among deep blue states like California, New York, and elsewhere, which has seen a whole crop of new gun control laws come up in sort of overnight, basically, that do a lot of fairly extreme things that almost feel like an attempt to thumb the nose at the Supreme Court, or it's almost like they want to have these laws be challenged and struck down. I don't really understand it, but I want to talk. You just give us a little overview of what some of the new laws are now in California.
Yeah, so one of them in specific wasn't a response to Bruin, but it's a specific response to Texas. And they made it very clear that it is a response to the Texas law on abortion bans. Mm-hmm. And I believe Firearms Policy Coalition actually was opposed that because they said, hey, if this goes through, other states are going to use this to restrict gun rights. And then California did. And in the bill, it's in the penal code now, because this law passed, they specifically mentioned that if Texas gets rid of their law, the California law will also disappear. And that's the law allowing private individuals to sue other private individuals or companies that engage in selling assault weapons and ghost guns as defined in the state legislature.
Yeah, that one's a little weird to me, though, for a couple of reasons. I mean, Texas did that so that they could avoid pre-enforcement, legal or the judicial blocks.
Yeah.
And obviously California's copying that, and FPC was right. And I warned the same thing at the time that the abortion ban passed. But the idea there was to try and circumvent any constitutional protections for abortion that existed at the time. Obviously, things have changed quite a bit since then. But they were trying to make something illegal that they couldn't just pass a law to make illegal. Whereas California's version is on top of, they already made assault weapons. You can't,
so it's already illegal to do those things. Yeah.
Now, but it does include there's a provision in there about legal fees for lawsuits against gun laws in California. If you lose on any point in your suit, actually, this may affect your suit that you're involved with. The plaintiffs would then have to pay the government defendants for their legal fees, even if they win ultimately the point that they're trying to argue. And are you guys concerned at all about that in practice in this case?
It's definitely something to think about. I haven't spoken with the lawyers specifically on the concern for that. I know the CRPA is big and involved in this, and it's something that they're trying to hush. They're trying to deter people from wanting to challenge anything. And I think that's very interesting, and it's very shady how they're trying to do that. I think that one kind of flew under the radar. I think the first person I heard about that from was Four Boxes Diner on YouTube.
Yes, he wrote a piece for us about it. Actually.
Yeah, that's super
Mark
cool.
Smith, Yeah, I mean, it's pretty radical. I mean, I think it's something that is more of a First Amendment issue than even a Second Amendment issue. Obviously, they isolate these legal fees to Second Amendment cases, or gun cases, but really, it's more of a First Amendment issue. It's similar to when like Los Angeles and San Francisco tried to bar NRA members from getting city contracts. Like, it's related to guns, but it's really a First Amendment issue. And
they're basically saying you don't have the right to argue against the government, which is kind of crazy.
Yes, I mean, I'd expect that one to not survive very long in this world, but I guess we'll have to see. And it is something that I suppose you guys need to be mindful of. But what else is California doing?
So one of the recent ones was a ban on 3D printed firearms, which was very interesting. It wasn't that 3D printing firearms was legal in any aspect. Prior to this law recently passing, you would have to go through the state to apply for a serial number, insert a massive chunk of metal into the gun to have the serial number put on, and then you could build it for any firearm that was made out of polymer. They recently passed a law banning the use of 3D printing technology to produce a firearm, even if you apply for the serial number and make everything compliant with the assault weapon ban and unsafe handgun ban. So now there is currently no legal route to 3D print a firearm in the state of California, whereas before there was, but if you didn't follow the laws, it was already illegal to make them. So they only people that they affected was me and a handful of other people that I know of that have legally 3D printed a firearm in the state of California. That was an interesting one. One bill that they're trying to push through is SB 918, which I'm not sure if that law is quite dead yet, but it seems as if it's losing traction. And that bill would essentially make it, in practice, almost impossible to carry a gun anywhere in public, because it adds a huge list of what would be considered a prohibited place to carry a firearm. And it would add the adjacent sidewalks to many of those places. Some of those places are hospitals, any building that is funded or owned by the government, any park, fitness centers, any restaurant that serves alcohol for consumption on the premises. So not just bars where the primary purpose is to sell alcohol. It would be anywhere that serves alcohol at all. So in practice, you would not be able to carry a gun and walk on the sidewalk in most parts of the city. So they couldn't make the entire state a sensitive area per Bruin, but they're going to make it in practice impossible to carry. Yeah. And that's an interesting one.
That's another New York copycat thing where it's just like, I guess you're trying to get the Supreme Court to take you back to school again. Like, it just seems like
it's a game of I'm not touching you. I'm not touching you. You know, they're asking for it, you know?
Yeah. It's fascinating too, because I thought that they would end up, it's been a bit surprising to me, frankly, because I thought they'd end up going more the route of DC. DC had a total ban on all gun carry. There were no permits. You couldn't do it in any form outside of law enforcement. And then that got struck down as unconstitutional. So they went to a May issue law that was modeled on California and New York and Maryland. And then that got struck down as well in Ren v. DC. And DC decided not to appeal that decision because they were afraid that they would lose if it got to the Supreme Court. And they explicitly said this at the time. The Attorney General Racine here said, we're not going to appeal this because we're worried we'll lose and it'll set a nationwide precedent instead of DC has its own federal circuit. So the rulings there only apply to DC. So they wanted to contain the damage, and they went ahead and passed the shall issue law, which just basically required a lot more training than most laws, 16-hour class with that's specialized for DC that has to be taught by people certified by the police department. And then it expanded how many gun-free zones there were, including permitted events or events that should be permitted. So any large gathering of people, basically. Yeah. And then it included a special roaming gun-free zone that follows anyone under diplomatic protection in the city around anywhere they go. So you're kind of supposed to, I don't know, I guess run away from them. In practice, they have to warn you.
You see them in Safeway and you got to run out the back door.
Yeah, basically. And I figured that was the direction that most of these states were going to go after Bruin, but it turns out that they're just going whole hog and saying, kind of screw you, the Supreme Court. We're just going to basically ignore what you said and pass laws that make it practically impossible. It's for people who have permits, it's harder to carry now than before Bruin. And I just don't see the Supreme Court letting that stand. I don't know.
I'm really interested to see how the California laws get affected, especially at the Ninth Circuit, because, the Ninth Circuit, California felt very comfortable appealing to the Ninth and appealing to the Ninth en banc because the Ninth Circuit accepted the means end approach, and everything kind of just, even if you won at the trial courts, even if you won at the district courts, if it made it to the Ninth Circuit, they were just going to kick it down or say it was constitutional. But now we've seen recently with at least Miller and Duncan, they've both been kind of kicked down in various aspects. And I believe Rupp versus Bonta also. So the Ninth Circuit is basically stalling for time. And I believe one of the judges in the Duncan case specifically said that they are delaying the inevitable, something along those lines. And we've seen cases just get kicked back down to Judge Benitez, who in the past ruled on Miller, the assault weapon ban, favorably, and Duncan, the magazine ban, favorably. So it's interesting to see that the Ninth Circuit is now just trying to kick it back as far as they can, delaying the inevitable, essentially. So I'm curious if we're going to end up getting things to the Ninth and if the state will appeal it to the Supreme Court if it's favorable for us. Obviously, we would love to have national precedents, but I'm very curious to see how that all pans out in the future strategically for the state.